Hello, my name is Peter Kempner, and I'm the legal director at Volunteers of Legal Service, also known as VOLS. I oversee the work of our Frontline and Healthcare Workers Initiative, and I'm here to talk to you today about the importance of planning for the future. When we talk about planning for the future, we're talking about having the right life planning documents in place in the event that you ever become incapacitated or pass away. We want to make sure that everybody's wishes are clear and they're being carried out by the people that they love and they trust the most. When we talk about life planning documents, we generally split them up into two different categories. First are the documents that are important during your lifetime, and this includes the durable power of attorney, the healthcare proxy, the living will, and a standby guardianship designation if appropriate. As far as documents that are important for after you pass away, we prepare a last will and testament, and then also an appointment of agent to control disposition of remains. Let's first talk about the durable power of attorney. A durable power of attorney is a really powerful document that gives the power to another person, known as the agent, to make property, financial, and other legal decisions for you. You're known in the document as the principal. It allows your agent to pay bills on your behalf, apply for benefits for you, and engage in other financial transactions as well. What would happen if you become incapacitated and don't have a power of attorney in place? Well, if you find yourself in that situation and you're unable to perform financial transactions, then one of your loved ones may have to petition the court for legal guardianship in order to act on your behalf. A legal guardianship proceeding is a long and invasive process that potentially strips you of your legal autonomy if a guardianship is granted. Also, bills will go unpaid, your lease may go unsigned, and you'll be at risk of losing government benefits if you receive them. This will only be remedied if a guardian is appointed by the court. And again, that is a long and potentially expensive process for your family. The next document I want to talk about is a healthcare proxy. The healthcare proxy is a document where, again, you're the principal and you name another person to be your agent, and they're able to make healthcare decisions for you, only if you cannot make those yourself. So what happens if you don't have a healthcare proxy? Well, if you become so sick you're unable to communicate with your medical providers, then New York's Healthcare Decisions Act will kick in, and it will dictate who will make medical decisions for you. Generally, the Family Healthcare Decisions Act will pick your closest relative, and they will step into your shoes and make your healthcare decisions for you. You will have no choice in who that person will be. And if there's nobody listed in the Family Healthcare Decisions Act who's able to act on your behalf, then your healthcare providers are under a duty to keep you alive by any means necessary. The next document I want to talk about is a living will. In a living will, you're actually able to lay out what treatment and care you want or you don't want at the end of life. The living will, unlike the other documents we've already talked about, does not name a person to make those decisions. Instead, it lays out what your decisions are in advance. And so what happens if you don't have a living will? Well, absent clear written instructions stating otherwise, and in the absence of an agent under a healthcare proxy or the Family Healthcare Decisions Act, then again, healthcare providers are under a duty to keep you alive by any means necessary. The next document I want to talk about is a designation of standby guardianship. In New York, if you're a parent or legal guardian of a minor child, somebody under the age of 18, and you're worried you might not be able to care for your child in the future, you could name someone to act as that child's standby guardian. Frontline workers with minor children might want to consider preparing a designation of standby guardian if they are or are to become the sole guardian of their minor child. A standby guardianship differs from a legal guardianship in that a standby guardian's authority becomes effective only if certain specific situations happen, and you maintain all of your parental rights until that happens. Under a temporary executive order, The ability to prepare a standby guardianship has been extended to anyone who works or volunteers in a healthcare facility or who reasonably believes that they may otherwise be exposed to COVID-19. Next, I want to talk about documents that are important after you pass away. First is the last will and testament. In your last will and testament, you say who you would like to inherit your property. That includes the contents of your apartment, your money, any real estate you may own, and that happens after your death. In it, you name somebody who's known as the executor to protect your property until all debts and taxes have been paid, and then to ensure what's left over goes to the people who you intend to give it to. Well, what happens if you don't have a last will and testament? Not only will the state decide who gets your money and property after you die, this process is called administration, but it also could cause problems and delays with respect to things you'd like to have carried out. This includes getting access to your apartment to retrieve your belongings and so on. You'll also not be able to appoint an executor of your choosing to be responsible for distributing your money and your property in accordance with your wishes. The court will choose who's in charge of your estate after you pass away if you don't have a last will and testament. Lastly, I want to talk about the appointment of agent to control disposition of remains, also known as the control of remains form. In this form, you're able to name a person to handle what happens to your bodily remains after you pass away. That is, you lay out in the document what your final wishes are. Do you want to be buried, cremated? Do you want to have a funeral or not? In this document, you can include very specific instructions and information, such as the location of your burial plot or where you'd like your ashes to be scattered. If you don't have an appointment of agent to control dispositions of remains, New York's public health law, again, creates a list of close relatives who will handle your remains. You'll not have control over who retrieves your remains, nor will you have control of what that person does with your remains after you pass away. The VOLS Frontline and Healthcare Workers Initiative provides all of these documents: last wills and testaments, powers of attorney, healthcare proxies, living wills, control of remains forms, standby guardianship designations for frontline healthcare workers during the COVID-19 crisis at no cost. In order to qualify, you must live in the state of New York and work in New York City and be a frontline healthcare worker. If you're interested in applying for these services, please visit our website, volsprobono.org, and click on the Frontline Workers tab. And then you could fill out our application, and if you're accepted, you'll be contacted by an attorney. Thank you very much for listening today, and I hope that you stay safe.